Okay, so I'm starting the recording now of this first tutorial in LAWS12065 Foundations of Property Law in week 2. So the tutorials will be recorded and posted to the Moodle website in the week following. But just give some thought to that. Really the only day for me presently would be a Friday evening. So I'm happy to entertain some thoughts on that, possibly a 7 to 8 slot on a Friday evening. As I responded to one of your colleagues, I did offer an evening session as the tutorial time in term 2 last year, but there were other students who found that difficult because of family commitments and so on. We can never get an ideal time for everybody. If you're not speaking, if you can just mute your mic, because sometimes you can get breathing coming into the mic and so forth. Thank you, that's great. So, you know, we can't always get an ideal time, and of course we want to maintain flexibility with regard to online education and the program, but we try and do the best to meet different people's requirements. Now, I've just given, in fact, it's 10 past 12, we'll start in. Now, the other thing I just need to bring to your attention up front is that we've had a few issues with the licensing of the Zoom, and so I get 40 minutes and then I can restart the Zoom session. So I will do that, okay, until we've sorted out the licensing issue, which will then give us an unlimited time space. So if it cuts off, I'll then reactivate it or attempt to reactivate it and start a second session, okay, so we run through for the time for the class. I've posted to Moodle just this morning a lesson plan for the class, and I propose to do that on a weekly basis. And just to give you a quick idea of what we're going to do is we're going to start with a couple of minutes taking you back to the icebreaker exercise, and I'm going to facilitate something on that for a few minutes, up to no more than 5 minutes. We're then I'll give you a brief overview of the course and where it fits within the sequence of the property law courses, which I've been designing and will be running as part of the law program. Then we'll launch straight into the tutorial problems, and there are 3 of those, and I've been monitoring people's posts on the Moodle website, which have been interesting, and some good thoughts there, and we'll hopefully engage with those. And then lastly, we'll have a wrap-up just in terms of what have we done, what have we achieved in this class, and we'll finish with what I'm going to call 3 takeaway points. And I want you to be able to write down what are the 3 takeaway points for you from this class, and then I want to encourage you to post those onto the Moodle website following the class, so we get some engagement around the critical points that you felt came as a consequence of being able to attend the class. Because clearly not everyone can attend the class, even if we move the time. So again, that enhances the overall learning. Okay, so in terms of the icebreaker exercise, you remember that the phrase that I put there, and many of you have responded to that on the Moodle website, which is great. Trespassers will be prosecuted. Yeah. What I want to do now is I just want to throw that over to you. Hi, Davina. Greetings. I just want to throw that over to you as a group. And basically what I want you to do is just to come up with a word. Come up with a word or a couple of words. I know you've put posts on the Moodle site, but a word or a couple of words off the top of your head, from your reading, from your thinking, from your reflection up until this point. What does that phrase, trespassers will be prosecuted, or a word, a key word within that phrase, mean to you? Over to you. Just volunteer your ideas.
I'll jump in. So, presuming that someone sees a sign, trespassers will be prosecuted. What is prosecuted?
Give me a word, Margaret. Prosecuted. No, give me a word that you associate with the word prosecuted or trespassers.
Oh, okay. Okay. Exclusion.
Good, thank you. Exclusion. Someone else? I'm just looking for a word. Any words? It's like a brainstorming exercise.
The one that stood out the most for me was private.
Private, good, thank you. Another one?
I would have thought ownership is
Who's
what
that?
stands out when I read that.
Please say who you are.
Jessica.
Jessica, thanks, Jessica. Ownership, someone else? John, are you there?
Yeah, can you hear me?
I can.
Yeah, no entry.
No entry. Good, there's not more than one word, sir.
You said a couple, one or more.
That's fine. Did I say that? Good. Holding me to technicality. Excellent. Other words that come from the words that have already been referred to.
Trespass, maybe meaning tort law.
Thank you. Thank you. Yep. Who's that? Was that from Kelly?
Felicity.
Felicity.
No, Felicity.
Felicity, thank you. Good. So there might be an indication of other areas of law. So we've got exclusion. We've got other thoughts that have been put forward. Other words. Just looking for words at this stage. Word association.
Reserved.
Say again, Davina.
Reserved.
Yes, thank you. Reserved. Another word. Authorised, coming from Jenny. Thank you, Jenny. Any other words?
Possession.
Possession. Who was that?
Jessica.
Thank you, Jessica. Okay, that'll do. Look, what is the purpose of that exercise of word association? The purpose of the exercise is to get you to relate words, concepts, and phrases of legal importance to your understanding, your knowledge, and your experience to date. Just one sec, sorry. Sorry, my gardener has just decided to come and mow the lawns. A bit noisy outside. So, the purpose of the word association exercise is to get you to intuitively and instinctively respond to these words and phrases which have been developed over time in whatever area of law we're focusing on, and ask, how do you relate to them? What are the words that give these words meaning for you? That's important because we always start our learning journey from our point of first reference and first engagement. And we build from there. And it's building blocks and it's learning blocks. Actually, that's one of the reasons why sometimes I get a bit concerned when some of my students say to me, "Oh, Michael, I want to get this course basically knocked over in about 4 or 5 weeks." And I say to myself, well, I understand that from the perspective of self-managed learning and lots of things going on in one's life. But remember that we design these courses and we're gradually building foundations and building blocks of learning and understanding and appreciation, and that has to occur gradually. And that's just something I want you to think about, because you're going to find the law of property very embracing. You're going to find it challenging. Some have already said that to me in various ways. All law is challenging, I know, but property is challenging because it actually reaches out and touches other fields of law. One of you have already indicated, I think might have been Felicity or Jessica, indicated tort law. That's true. It also reaches out, in some respects, arguably into public law. The first topic refers to the Constitution. The Australian Constitution refers to the Constitution of the Republic of South Africa. It's part of my internationalisation of the property law curriculum for you. And insofar as it reaches out to these other areas of law, then it requires an appreciation, not necessarily a complete, thorough, grounded understanding of all those areas before you study property law, but an appreciation of those areas, and that's the reason why we set the prerequisites as we do in this course. The other challenge is the language, and I highlight this for you in the notes. language is, as we know, challenging always in law, but the particular challenge in property law is a lot of arcane language, a lot of phrases that aren't familiar to us from a previous period, because property law and our understanding of property law notions travels and traverses a millennia. We travel back at least, and I say at least, until 1066. There's 1,000 years of history, of culture, of social development, of political upheaval, and of how people relate to what property means.
Michael, could I just say there too, in terms of when you're talking about different laws, for me, native title, and then also when you're talking about going back in time, to look at that whole aspect of time and how Aboriginal and Torres Strait Islander people view property. And some of these concepts, I'm still having a bit of difficulty aligning that in my head and knowing I have to do these things for property, but also with that other understanding that's there about the value, the significance, the cultural aspects, the spiritual aspects of what land is.
That's a point well made, Margaret. And I saw in some of the Moodle posts that discussion about native title, and are we covering native title, or is it more covered in land law? You will see information in the notes in the coming in topic 5, which will be posted soon, that we do actually traverse native title in various ways, and I've deliberately done this because it's so significant. We will be dealing with it in topic 5 in this course in an introductory way in the context of land tenure. We will be dealing with it again in topic 7 with regard to the rights of Indigenous people and public land. And then we will be dealing with it more systematically in terms of, in land law, 12066, under a topic specifically about the elements and the requirements of native title under legislation of common law. So, point well made, Margaret, but I would also respond to that to say that all people have a relationship with land. And Australia today is a multicultural society. But here is another challenge. The challenge is that our property law within the system of, maybe I can use this phrase if it's acceptable, whitefellas law in terms of where that's come from, it's very an English origin. And yet we have people in this country from all around the world who have come from all different parts with all different legal systems and all different ways of relating to what land and what property means, but they must work within the parameters of what property law and the legal framework of property law as it operates within the society that we have. But of course, native title is something that we need to separately investigate. This course, just very briefly, a couple of points. I've deliberately called the course Foundations of Property Law because it is building foundations of conceptual and philosophical understanding. It is also introducing you to key concepts of property law that is relevant for an understanding of personal property, often in the form of goods, and realty or real property, what we would call land, but land is a very holistic idea. There's a more thorough investigation of land law and the various elements and requirements of that in the course you'll study in Term 2, 12066. But we introduce you to aspects of land law and ownership of land and so forth in this course, as well as in relation to property. Another aspect of this course, which is another challenge, I suppose, is that in introducing you and moving you through an understanding of concepts that draw from common law as well as from equity. As we move through this course towards the latter stages and then into land law, you will see the intervention more and more of legislation. But the working together of common law and equity is not always straightforward. And there's a need to grasp an understanding of how these sources of law work specifically with respect to understanding what property law is. All right, it's now 12:25. So with those overview remarks about the course and your comments with regard to the icebreaker exercise, let's move directly to tutorial problem number 1. Now this problem, as many of you have already read, many have already posted on the Moodle site, is focusing on the Victoria Park Racing and Recreation Grounds and Taylor case, an early High Court decision, but a landmark decision and still critically relevant to our initial understanding of what property is and what it can be. And the focus on the idea of a spectacle, and can you own a spectacle, and is there property in a spectacle, and so on and so forth, and the different judgments. Can I just say, before I open up to let you make your observations and comments, there's been a few queries about where should one start? You know, property law, it seems a bit overwhelming. You know, there's a number of resources being used, casebook, textbooks, chambers, the casebook 8, which I'm abbreviating as APL, and so on and so forth. Let me encourage everyone in the course to go through the hard yards of working from the primary materials in the casebook and then go to the secondary sources of doctrinal textbook and so on and so forth. Certainly have my notes to guide that, but work with those primary materials, the cases, the extracts from the articles, the materials, extracts from Law Reform Commission reports of reform and review and so forth. So you can sort of peg out the landscape for yourself in the first instance. That's all law students must do that. And we can't shy from the fact that it's hard yards, and that's how law is grasped. There's no doubt about that. And then we can then start to put the mosaic of the puzzle back together, gradually, step by step. Okay, I want to open up to the group in terms of problem question number 1. Just remind you too, of course, class participation doesn't start this week. It starts with tutorial from number 3. And the assessment period runs from week 3 to week 9. So there's no actual class participation assessment component on this first tutorial. But insofar as class is assessed, and I'm also monitoring Moodle posts and so forth, you can anticipate, as I think I put a post on the news forum about this, you can anticipate me asking you questions directly and not just waiting for people to volunteer responses. But I want people to volunteer responses, and I want there to be an interactive discussion, because that's what makes for a vibrant class within law teaching and learning. Okay, so over to you in terms of tutorial problem number 1.
Well, I'll jump in.
Please.
Just in relation to that first question about why it's not possible to own a spectacle. Yes, one of the first things I did was just to go and see, well, what is the definition of a spectacle? And then reading through the text to see that it's really what people see. And I took it to be the proof of the spectacle. It lies in the appreciation of those who see it, not necessarily the people who design and showcase it. So I'm not sure if that's one of the ways.
You'll notice me doing this. I will interrupt you, not to you, Margaret. But this is my method. It's called the Socratic method of legal learning, right? So my purpose here is to interrupt at times in an appropriate way, to guide, to direct, to refocus, and so forth. Can I just say that idea of thinking about the definition of the key concept is important, but in law, we ask ourselves, where do we go to find the definition? Does anyone want to respond to that? I'll come back to you in a minute, Margaret.
Legal dictionaries?
Good. Legal dictionaries are good. Standard English dictionary? Anyone else?
That'd be my second base.
Second base, right. Anyone else?
I go encyclopedias like Halsbury's or something like that.
Good, very good. The point being that we need to inform ourselves broadly because what we need to ask ourselves is, what does this word or phrase mean for legal purposes, not just generally? Of course, we're aware that the idea of a spectacle, or the word spectacle, is we can use it in the context of saying, oh, he or she is making a spectacle of themselves. And that seems to have negative connotations. But in the context of the Victoria racing case, that really wasn't the way in which the word spectacle was used. So first of all, we need to understand what is the key idea that's being focused on in the case or in this part of the law that we're thinking about. Secondly, what does the word or the phrase mean for legal purposes? And then thirdly, what does it mean with respect to the particular subject or area of law that we're thinking about? So what does it mean for property law purposes, not just legal purposes or for law generally? So you can see there's a cascading process of garnering deeper understanding and learning. But yes, it's good to start, get those key words, those key concepts. What do they mean? We don't necessarily have, a complete, conclusive answer to that, but it certainly guides us a bit more. Margaret, do you want to continue?
It's just going along from that then, to have, as I said, for me to go and look to see what that word meant. I guess I would look at it from what a general view is of a particular word, then go to see what it means in legal terms, and then also look at it, as you said, within the context of the particular subject we're looking at, which is property law.
Yeah.
But I think, again, that gives, as you said, that gives you a good, well-rounded view then of what it means. So you can understand if people are raising that word spectacle, you can have some discussion about what their viewpoint is of it, and then how it gets broken down into a specific in relation to the subject we're talking about. So
that's good. When we are answering questions in these tutorial questions, we are also practicing the analysis and the logical rigour that is required to answer questions initially for our purposes as written responses to the assessment tasks, which will be the online quizzes, which I can tell you now will not just be MCQ questions. They will require reflection, thought, and some discursive answer for most of those type of questions, even though they're through an online process, because that's appropriate given the fact that you're all external students. And then also for, ultimately, of course, for the final exam, which in this course is a take-home. So we're developing, as we proceed through working on these tutorial problems, not just having an open-ended discussion, but developing our skills of analysis, logical and analytical review, and the capacity to reduce that in written form, ultimately. Be able to articulate that. That's a very important skill of any legally trained individual, but also in written form. So, for example, in this question, we notice that there is actually several questions within the question. We notice that there is, and Margaret, I think, was indicating, I'm dealing with the first part of this question. The first part is dealing with a spectacle, but not only a spectacle, what's the other concept that's identified in that first question within the question, if you like?
Can it be owned?
Owned, ownership. You're also looking for the words with property law significance in the question, because that's the purpose of the question, to test your understanding of the concepts and phrases with property law significance. So the first part there is about the ownership of a spectacle. So that requires us, of course, to ask, well, what do we mean by ownership? Ownership by whom? What is required for there to be ownership? Now, we don't necessarily know that at this point because we haven't fully explored that, but that certainly is something that has to be addressed in thinking about whether you can own whatever this thing is that's a spectacle. Right? Would someone else like to buy into the discussion at this stage?
I thought it was interesting, the idea that you could own a race, like that you could own viewage and commentary on a race rather than just the land and just the horses. They're owning, well, as they say, the spectacle. I was surprised that they could actually fight for that.
But that was the argument, of course, that was presented by the lawyers for the Victoria Park Racing and Recreation Grounds Limited. And notice, of course, that it's a company, okay? Notice, of course, back in 1937, was it, when the case was decided? Anyway, whenever, yeah, 1937. So notice that this is another thing to tease out, is that this is a dispute between a company and a person, but a person who was in effect, at the end of the day, viewing and commenting on, ultimately for the purpose of broadcasting, because that's what they were doing. Yeah? And arguments are trying to be brought from both sides to either allow or to acknowledge or to recognise in law on the one hand, that's Taylor's point, the entitlement to do this, and the Victoria Park Racing Grounds Limited, the company, trying to prevent that. Why? Why are they trying to prevent this? What's the purpose? What's the underlying reason?
They want people to be able to attend the race and see it from their land, because if they get them to their land to watch it, it means that they would be benefiting out of it. They might have to pay admission costs. They'd probably buy drinks while they were on site. They'd play bets on the horses.
Right.
If you watch it from your backyard, they would miss out on all that.
So therefore, what's the driving agenda behind the case, if you like?
Loss of profit.
Financial factor.
Sorry, who was that?
So this is Jessica.
Yes,
And I
thank
was
you.
just saying there's a financial factor, an economic factor.
Yes,
that
yes,
They have an interest.
yes.
Yeah,
Commercial.
loss of profit.
It's a commercial imperative, isn't it? So the recording is going to finish in 10 minutes, but I will then seek to reactivate the recording by creating a new one, and then we can all log into that again for another 40 minutes. Okay, just letting you know that because of this issue of licensing for the minute. All right.
Will that be a different meeting number?
It may, and I will send that directly to you by email. Post it
Okay.
on Moodle, and so it might be a 5-minute delay, okay, while I set that up, okay? So just letting everyone know about that, okay? I apologise for that. We just had a few licensing connection issues. And not only myself, it's been a few of my colleagues as well. So, yeah, I mean, one of the things is you have to dig beneath the surface of these cases. Challenging, I know, because the cases themselves and the justices of the High Court write in a way that they contain themselves to the legal argument, they contain themselves to developing their understand the development of what the law means in this area. All of the discussion in the Victoria Park Racing by Latham and by Dixon and by Evatt and by Rich is all in the context of legal discourse. Except which judge indicated something more than just the legality of what was going on here, do you think? If you have a look more carefully at the judgment of Justice Evatt, and also arguably the judgment of Justice Rich, you will see indicators of broader themes. Right? So, for example, Evatt was concerned about, he referred to things like the systematic way in which this was being done by Taylor and his associates, and also the extent to which that what may be attacking the commercial goals of the racing Victoria Park Racing Ground Limited. And then there was also an indicator, I think, in Rich's judgment with regard to broader ideas, and certainly in some of the judgments with regard to the implication of broadcasting rights and so on. And one of the posts on the Moodle side indicates, of course, that the case may be decided differently today in light of broadcasting legislation. And also the social context is important. I mean, how do we deal with that in this country as opposed to in other parts of the world? And even at that time, there was a suggestion of differences between the United States and Australia, for instance. So one of the things that you have to do in law, in your legal studies and as you progress through, is on the one hand, you have to get a good solid grasp of the legal fundamentals within the area. So in this area, for example, and this question is deliberately trying to get you to think seriously about what property can be and what ownership of property is. We don't necessarily have a total comprehensive answer to that question, but that's a central question, okay? But you also have to look beneath the surface and have to ask, what are the underlying goals and motivations in the parties in bringing an action forward in the way that was done in these proceedings? Don't forget, people, that a High Court challenge is costly and time-consuming. Going back even to Margaret's earlier point about native title, the person who initiated the action in the Mabo case unfortunately died before the whole process reached its zenith. And that's not the only situation in which that occurs. Sometimes High Court decisions, it can take 10 years to get that ultimate decision. The High Court today has the right to the process is that they must grant special leave to hear an appeal, and they'll only hear appeals on important cases involving important issues of principle or the liberty of a person, so on and so forth. The interesting thing, even in 1937, was that many of the cases that were taken to the High Court were either by governments or by companies and so on and so forth. So those practical dimensions are also need to be a part of your framework of thinking in terms of how the law evolves and emerges. Okay. What about just the last point? We've got about 5 minutes left before I need to do the recalibration in Zoom. Just the last point with regard to explain how the case applies with changes in communications technology today. And there's been a few posts on the Moodle site about that, which have been nice. Anyone else who hasn't spoken yet like to contribute on that last part of problem question 1? Anyone who has spoken yet like to contribute?
I guess it'd just be now pretty much anyone could do it even from the course. I mean, now you could probably post it as do it via Skype or something like that, and you'd be able to video the race as well as comment on it from your cell phone. You wouldn't need to call someone from a backyard and broadcast it on the radio. Now you could just do it online.
But does the result in Victoria Park racing make that easier today or more difficult, or is the situation unchanged in that respect? Anyone else?
I think that it'd almost be impossible to police it from that point of view. It'd be impossible to stop people from taking footage of it, making comments on it and broadcasting it. It'd be almost impossible to police it.
In fact, the reality surely is that today the facility and the convenience of making recordings or of observing spectacles, whatever that embraces, is much easier today with technology. You know, I was thinking, I saw a couple of the posts on the Moodle side, and I've seen this myself. I mean, I even had some friends, for example, say, and even sent me, you know, they've been on a train and they're recording something that's happening in the public space, and then they're sending it to me, or they're posting it on Facebook, for example. Right? Now, if we'd had a result the other way in Victoria Park racing, this would have put huge constrictions on the way that we can function today in our society. But on the other hand, there needs to be a limit in terms of what can and can't be done. Now, not all of these issues can be resolved through the law of property. Okay, we've also seen, regrettably, very inappropriate recordings and capturing of images and so forth. And there are other responses by other areas of the law and the society as well. But remember that what we're focusing on is, you know, be that as it may, but we're focusing on property and what can be property. And in this case, the performance, the spectacle of the race on the racetrack, there was no property that could be had in that. Okay, so anyone can look at it and view it and so forth. But the point is, of course, if you go onto the ground and if you pay the fee, your experience is quite different to someone who listens to the broadcast, whatever. It's a bit like whatever thing that you like to do, whether it's going to a concert, or whether it's going to the football or going to the cricket or whatever. Being there is quite different to watching it on TV or listening to it on the radio. Right? I personally, actually, with cricket, I like to listen to the ball-by-ball descriptions. A bit old-fashioned in that regard. But anyway, so that's the... Yes?
Sorry, just to ask a question about that.
Running out in less than a minute, just to let people know, okay?
Sorry. Can it be used in a court of law, like a footage that's taken on your own cell phone? Say, for example, you've done an illegal act, but you recorded it on your phone. Can that be held against you? Because it's your property?
This moves outside of the law of property, of course, because it might
Copyright.
might violate other issues. Who was that, sorry? Someone mentioned the issue about copyright. Yes, so issues about copyright could be surfaced, and that can be a part of intellectual property, which we don't specifically look at in the course, but anyway, it can be that. The other issue, it can involve issues of criminality, so the criminal law can get involved, and so on and so forth. Remember that, there's a whole lot of areas that can impact upon human activity. Our focus at the minute is property law, and for the purposes of this course. But good point, and you need to think about how the law can impact upon things that we're focusing on for the purposes of property law, okay? All right, I don't know, we're just about to run out, I think, so hopefully when we come back, we will be able to move on to problem question number 2. Are we going to run out yet? Not yet. Okay, we can make a start on problem question number 2, and if it expires, it just runs out, then I'm just going to recalibrate as I indicated to you before. So problem number 2